Welcome, everybody, and thank you for joining us today. My name is Cristina Duc, and I am a partner in Baker McKenzie Barcelona. And thank you for joining in this session, Litigating Designs in EMEA, All You Need to Know. As probably you know, this is the last session in a series of a webinar that we have been giving during this week, also in other regions in Asia Pacific, North America, and Latin America. At the end of the session of today, we will provide you with the details in order for those of you who would like to also see the other sessions. Before starting, I will provide you with some housekeeping. We encourage you to submit your questions by using the chat function. We will do our best in order to respond to these questions. We pretend to be this quite lively, and also you will be asked to participate in some polling questions that we will be launching in the middle of the presentations. Finally, just let me tell you that this is a recorded session and that we will be sharing the slides and also the video with you after the event. The agenda of today, you are seeing in your screen. We will be focusing the first part of the presentation in some general concepts about protection of designs. And then the second and third part of the presentation will be focused on litigating designs, some indications about the injunction measures and means of defense, and finally the main dispute, which will be focused on the evidence support. And finally, we will have some time for questions. The speakers of today, you see them. I am very pleased to be joined by my colleagues, Eva Maria Strobel in our Zurich office. She will be the one leading the first part, an introduction of the session. Then the second part will be led by my colleagues, Michael De Brooy in our Antwerp office and Nathalie Marchand in the Paris office. And finally, the last session of today will be conducted by myself, as you can see in the slide. I believe we are going to start with our first polling question. And I would like to ask you to respond by using the click buttons. And the question is, do your organization actively pursue registering design protection? Yes, no, don't know. Please go ahead and submit your responses. I'll do it also. And the responses reveal that yes, in a 55%. So that means that we have the proper audience here. And those who said no, let's see if we can convince you. And with that, I kick off and I give the floor to Eva Maria. Thank you very much.
Thank you, Cristina. And thanks for your responses. So yes, it shows designs matter. I would say it's undisputed that the design is crucial for the success of a product. So think about the tablet or the smartphone, which you are using now for this webinar. Why do people pay a lot of money for these kind of products? Is it because of the reputation, image of the company which produces them, because of the quality and functionality of the product, or is it because of the appealing design? And the answer is probably the typical one for the legal profession. It depends. It's very likely that many or even all of these reasons do affect the purchase decisions. We have a choice between a broad range of products to choose from, and many customers base their buying decision not only on functionality and quality, but also on a product design. But how and for how long can you protect a product as a design? Do you know that? Let's do another quick poll. And the polling question, which you see now, is, do you know how long registered design protection lasts for in your key jurisdiction? Yes, no, or not sure. Okay, can we see the answers, please? The Responses reveal, yes, 61%. Most of you do know that registered designs are not like trademarks where there is the ability to continually renew, but they are valid for a set period of time, and knowing the time frames is important. This needs to be kept in mind when discussing now how product and how the design of a product can be protected. So let's move on to the next slide, please. And to stick to the example, the manufacturer of the tablet or the smartphone that you are using, and no matter whether it's the US one or the South Korean one, the manufacturer probably has tried to protect its product and the design with many different layers of IP rights. So what form of protection is your smartphone, is your tablet eligible for? So is it trademarks, two-dimensional, three-dimensional trademarks? Is it copyrights? Is it registered designs, unregistered designs? Is it all of it, none of it? Is it maybe passing off, unfair competition? And which protection is most effective? Which protection lasts longer, or maybe long enough? We heard about the limited protection for designs. Each of the IP rights, which I just mentioned, have their very own requirements for protection and advantages and disadvantages. So let's look at the design. When is a design eligible for protection? Under EU law, the definition of a design means the appearance of the whole or of a part of a product resulting from features of, in particular, lines, contours, colors, shape, texture, and material of the product or of the product's ornamentation. So from an EU and EMEA perspective, designs can be products, sets of products, packaging of products. They can be complex products. They can also be parts of products or of complex products. Under EU law, only if the protected part remains visible in the product. In Switzerland, for example, there is no such visibility requirement. Designs can also be web designs, computer icons, graphical user interfaces, and, as I said before, ornamentation. If you attended the North America session on Tuesday, you will recall that ornamentation cannot be protected under US law, but it can under EU law, also under UK or Swiss law, to name just a few. In most jurisdictions in EMEA, such as, for instance, in Switzerland, design protection always requires a registration. In the EU and in the UK, there's also an unregistered design right, which lasts only for 3 years, not 25, and which is linked to certain other requirements and limitations. But today we will focus on the registered designs, and now move on to the next slide, please. When we look at the different routes to design protection from an EMEA perspective, the world of design registration can appear quite complex because we have different overlapping design regimes. So first, the national design regimes. A national design registration provides protection only in the country where you have filed for the registration. So if you want to protect your design in Spain, you file it directly with the Spanish Design Office. If you seek protection in several or even in all EU member states, then protection at the EU level, the registered community design, may be the right choice. So a registered community design, or RCD, provides protection in all member states of the European Union, so currently the 27. And finally, you can file for an international design registration under the Hague Agreement. Just like the international trademark registration with which you may be familiar, an international design registration is in fact only a bundle of national design registrations. You can file it with WIPO in Geneva, and just as with the international trademark registration, you specify the countries in which you want protection, so you tick the designations. Contrary to the international trademark registration, you do not need an earlier registration in one of the contracted countries. So you don't need the home or base registration in your own jurisdiction when applying for an international design registration. So there are 3 different routes to get to design registration, but what's the value? What are the benefits? Why would you choose to go either route? Well, first, because it's very quick and easy to obtain registration. There is only a formalities check. There's no substantial examination. So formality check, that means checking things like whether the application is in the approved form, whether it identifies the product, whether representations of the design file to comply with formal requirements, etc. But there's no examination as to whether the registered design is novel and whether it has individual character, whether it's therefore valid. This substantial examination is only undertaken post-registration and only upon request by a third party in cancellation or infringement. Michael will tell you about that in a few minutes. So you might end up with a registration which eventually is never substantially examined. And even such an unexamined and unchallenged registration might act as a very strong deterrent. The registration gives you instant protection. So whereas protection under unfair competition passing off first requires building of reputation through a long-term use. And under most EMEA laws, there's a presumption of validity, which is why the registered design is a great gateway to on and offline enforcement, including customs notices in many of the EMEA jurisdictions. But there are also a few pitfalls which I want to share with you. So let's move on to the next slide, please. And let's start with the obvious. The design which you want to protect has to be represented. If you file a representation which for some reason is not admissible, then in most cases, your only choice will be either to delete the inadmissible representation, which might be an option if you file several representations, or you will lose the filing date, your filing date. So before you file, very carefully check that all your representations are admissible, and in particular, that they do show views of exactly the same design, so that all the features shown match in the different views which you submit, because this is a very common mistake. And also be mindful of the quality of the images you file, whether they are suitable to show the features of the design that you want to protect. So how do you represent the design, the key features that you want to protect? You can use line drawings, you can use computer-aided renderings, or you can use photographs. If you use line drawings or renderings, consider whether it's possible to, in addition, also file a photograph of the product, because that may assist you in interpreting the design at the time of enforcement. And whatever representation is chosen, please keep in mind that in most jurisdictions, the design needs to be shown against a neutral background. You can use representations in black or white or in color. Importantly, the color is also a visual feature that is protected by a design registration. And so is also, for instance, transparency. So the question you should ask is the color or transparency imperative for the design? If it is not, then filing in black and white may give you a broader enforcement scope. In most jurisdictions in EMEA, when you file a design application, there's a field where you can describe the designs in words, but the protection eventually is determined by the images only, regardless of any description. So for this reason, make sure that the pictures or the drawings you submit, that they are clear and self-explanatory. And critically consider what and how many representations you file, having in mind that some jurisdictions impose limitations or very strict requirements on the form and on the number of representations permitted. In the EU, one representation, one view is sufficient. Up to 7 views can be filed in total, and you are completely free to choose the views. But in other jurisdictions, you may need a certain set of views, including like a perspective view, a side view, etc. So this needs to be considered. And even if you are very free to choose the views, always ensure that the representations really show all the key features of the design, keeping in mind that the courts will decide the issue of infringement by comparing, on the one hand, the infringing product, and on the other hand, the representations which you have filed. So next slide, please. The second most common pitfall is the lack of understanding that to eventually enforce a registered design, the design needs to satisfy a novelty threshold and establish individual character. As mentioned before, there's no substantial examination. So you may think, so why should I care about novelty? Well, because novelty and individual character will be assessed by the courts when you want to enforce your rights. So you better self-assess at the time of filing, because otherwise you may end up with a registration which is not worth more than the paper it's written on. The novelty of the design is tested against the prior art base for the design. And in most jurisdictions in the EMEA region, the prior art base includes any design published anywhere in the world before the filing or priority date. In some jurisdictions, such as Switzerland, UK, EU, there's a 12-month grace period available for registering a design following your own disclosure. However, you should not take advantage of this grace period without really fully understanding the risks of doing so, because most other countries around the world, in particular in the Asia-Pacific region, they do not have a grace period for disclosure. So by disclosing your design before filing your EU or Swiss or UK registration, you potentially destroy any possibility of validly registering your design overseas. Also, if you launch a product before filing a design registration and a competitor subsequently launches a similar product before you register, then no action can be taken unless you can prove that the competitor indeed copied your design, so that the competitor was aware of your design and did not create this independently. I'm not suggesting that the grace period should never be used. There may be very, very valid business reasons to defer the cost of registration and until the commercial success of a product has been shown. And also reviewing your already existing registrations within the grace period and potentially adding more designs, more variants, more colors may be a very good idea. But at the very least, you should discuss this with an attorney before your design is disclosed, because that way you can ensure that you have the best strategy. Apart from novelty, you will need to ensure that the design you file has individual character and does not consist of non-protectable aspects. For instance, a right in a registered design will not subsist in features of a product which are solely dictated by the product's technical function. But European courts have given a lot of guidance on the scope of the exclusions which apply. So this brings us to the third most common pitfall as we move forward to the next slide, please, which is that the monopoly which is granted by a design is limited to the design represented in the design application. It is therefore critical to think very carefully how to present what you want to protect to obtain the broadest scope of protection. So the key issues that you need to consider include: what is the key feature? What are the key features you want to protect? Do they apply to all the product or only to part of the product? Keeping always in mind that not all countries permit protection of parts of product. Think also of the advantages of filing multiple designed applications versus a single design application, be it for different parts of a product, for different variations, for instance, with or without certain features or colors. But again, that may affect the scope of protection. Under European law, there's also a number of permissible ways to exclude certain features from the scope of protection of a design. You may wish to do this because certain features may be useful to illustrate the context, the environment in which the design is used, but they are not protectable as such. Under EU law, for example, the use of boundaries, of coloring, of shading, of dotted line, broken lines is permitted. However, the interpretation given to features shown, for instance, in dotted lines by courts has proven to be less straightforward than what we would have expected. The EU IPO and national courts are not fully aligned when assessing the scope of protection of designs containing such features. And in particular, in multi-jurisdictional filing programs, use of these tools may not have the intended effect at all, as it's not accepted globally, and dotted lines, for instance, may be interpreted literally. Also, carefully consider what features you want to disclaim. There are several designs on the register in which the vast majority of features has been disclaimed. So only a very common and non-essential or unimportant feature actually is left in the design. And such an extreme cropping may lead to the design being either invalid or being given a very narrow scope of protection that can be enforced only against an exact copy. But enforcement of a design, defense against enforcement, that's something Nathalie, Michael, and Christina will now be talking about. And so I hand over to you, Nathalie.
Thank you, Eva Maria. So next slide, please. So this second part of the webinar of today will focus on design litigation. And before examining the nuts and bolts of the design litigation strategy, we wanted to discuss with you some upstream actions to improve your position in a litigation. Next slide. So more particularly, we want to focus now on design coverage of competitors and how to keep them on the radar. So we will discuss what type of monitoring you should do or what you can do and how it can help you in the litigation. Next slide. Before we start, let's have a polling question for you. Do you actively monitor your competitors' product for design infringement on a regular basis, never, or from time to time? Yeah, so the majority of you responded from time to time, which is not surprising because we also have this impression that design monitoring is less widely used than trademark monitoring, for example, even though it is, of course, key in design enforcement programs because it helps you to swiftly take the necessary action. So let's go to the next slide. So how to keep your competitors on the radar. The goal is to be able to take the appropriate actions quickly. And there are 3 questions to consider when it comes to monitoring: who, what, and how. So who. Sometimes who for some of them might be easy and for some other more difficult because you cannot easily identify your competitors that are filing design application or that are using design as part of their IP protection strategy. So the first question is to identify those of them that are using proactively design to protect their product or to compete on the market, to be able to launch the appropriate monitoring against them. These, of course, can be launched not only against competitors, but you can also consider monitoring your partners, some vendors, or some distributors, because you want to be cautious of what they are doing. Then the next question is what and the object of protection. So as Eva Maria mentioned, the design can protect various type of feature, type of object. So you need to select the object of protection you want to be cautious with. And of course, you also need to consider the market on which you want to do the monitoring. If you want to do that in the EU, you will do that with the EU IPO. But if you want to have a more global approach, you need to select the registry that you want to monitor. And then it comes to the practical question, how to do that. There are various types of monitoring that can be done. It can be done internally. You can do that with search on database like DesignView. When doing this type of search, it's useful to refer to the Locarno classification. I don't know if you're familiar with this classification. It's a classification that is similar to the NIST classification that we have for trademarks, but that is used for design in order to facilitate the search of design. And also this classification is sometimes used in litigation and in conciliation action to define the informed user. So this is the monitoring itself can be done internally. You can also rely on service provider, IP agent, law firm to do that for you. And also you can find on the market some companies that are specialized in market search generally and can do monitoring on the market on specific products. Next slide. And of course, it is important to be mindful of its own product while doing so. It means to be aware of the source of inspiration of your own product and depending on them to make sure you have in place the necessary clearance, the clearance that can, because you can, if you anticipate a risk of your own product, because you want to avoid a boomerang effect and to have against your company a cancellation action against your own design, this clearance is very key. So it can be done on the name, on the appearance of the product, on the technology, whatever, depending on the risk that you assess. Next slide. So now I will hand over to Michael for the discussion on enforcement strategy.
Thank you, Nathalie. So once you've identified a potential infringer, it's time to think of the enforcement strategy and some precautionary measures. Next slide, please. So when we think of enforcement strategy and precautionary measures, we have to think of pre-trial actions and some other strategic considerations, such as where to bring an infringement claim and the available remedies. Next slide, please. So then turning to the pre-trial or pre-litigation actions. So when you've identified a potential infringer, the first step is often to send a cease and desist letter, also called a letter of claim, a letter before action, to assert your rights and to inform a potential infringer that you're willing to take action and stop the commercialization of the infringing products. This will typically trigger a response, either compliance or settlement negotiations, or simply a dispute. If you wish to keep the element of surprise, you might want to skip this step and just go straight for measures for preserving evidence. What is this? This implies going to the court, sometimes without hearing the other party, and ask the court for an order to go to the premises of the infringer, sometimes with the assistance of a bailiff and or a court-appointed expert, to take samples, to go through the books, to describe the infringing items, and then to collect evidence, basically to then decide whether or not to bring an infringement claim. A third option is to seek provisional and protective measures. This refers to a preliminary injunction or the physical seizure of infringing items and materials. This typically requires a proof of urgency. Two things to consider is where to bring a claim. So typically you have to file this claim before a specialized court. For instance, in the EU, these are the community design courts, but the European Court of Justice has also held that you can bring such a claim before a court that has jurisdiction in respect of a national design. Note that if you're enforcing a preliminary injunction, you do it at your own risk. So if subsequently the PI is overturned or revoked, then the defendant is entitled to claim damages by way of an appropriate compensation. The European Court of Justice has there set the bar relatively high by saying that the defendant in that case has to prove that the plaintiff has committed a wrongful act when enforcing the PI. Important to know is also that a design is presumed valid in an action for infringement or threatened infringement. So this means that for a registered community design, for instance, the validity can only be challenged by way of a counterclaim. So only saying that the design invoked is invalid is not suffice. So a mere plea will not be enough. You will have to formally make a counterclaim. However, in summary proceedings, a mere plea will suffice for the simple reason that in summary proceedings concerning provisional measures, it's typically not possible to file a counterclaim for invalidity. In respect of a unregistered community design, you can raise a mere plea or a counterclaim. Another point to consider is the territorial scope of the measures. So when you want to obtain pan-EU measures, you have to file your claim before the courts of the defendant's seat or establishment. If the defendant has no seat or establishment in the EU, it has to be the plaintiff's seat or establishment. If the plaintiff has no seat in the EU either, it has to be the EU IPO seat, Alicante in Spain. If you file the claim before the courts where the infringement occurred, non-EU countries, or in respect of national designs, then measures will be limited to the territory of that country. And then important also the related actions. So this is the case where an invalidity action, for instance, is already pending, for instance, before the UIPO against the design that is invoked. If you then as a design owner want to file an infringement action, the infringement court will normally have to stay the proceedings unless there are special grounds to do so. For instance, if the invalidity action before the EU IPO is manifestly unfounded. However, the design owner luckily can obtain interim relief in the meantime and ask the court to order provisional and protective measures for the duration of the stay. Next slide, please. Then the available measures and remedies following a full trial. These include injunctions, but also seizure of infringing products and materials, Also corrective measures, recall of products, removal of products from the channels of commerce, destruction of the products. The design owner also has a right to information on the origin and the extent of the infringements. This can be filed both before, during, or after the full trial. A design owner can also claim damages, lost profits, lost royalties, sometimes also moral prejudice for the loss of exclusivity, an account of profits, so that's a transfer of unfair of the infringer profits, which will typically require proof of bad faith. Publicity measures, so publication of the summary of the judgment on the infringer's homepage. Legal costs, so this includes attorney fees and technical representation fees. Customs enforcement, detention of infringing goods at the borders, and then if you find these goods on a platform, then you can obtain usually a takedown. You can follow a takedown process. Next time, please. We will now discuss the means of defense and alternatives from the defendant's perspective. What can you do when you're confronted with a claim? We will here focus on two mechanisms that are most common in such a case, namely the non-infringement action and an invalidity action, for instance, before the EU-IPO. Next slide, please. So the non-infringement action. So first, what is it? When you are confronted with a claim, a letter of claim from a design owner, you can also take a counter-attack and go yourself to the court and ask for declaration that your products are not infringing another's design. Why would you do it? Is to take a proactive step to anticipate potential infringement rather than delaying the product launch until the design right expires, is to provide certainty for businesses who wish to launch safely. And there may also be other strategic considerations, such as choosing the forum and stay in the driver's seat. Wherever you have to do it before the specialized courts. So in the EU, that would be the community design courts. There are 27 of those. It's not available in all countries. For instance, it's available in large countries such as Germany, Italy, Spain, and also the UK, Switzerland, but not in France. And the procedures and the principles vary significantly. And now I will hand over to Nathalie to discuss the invalidity action before the EU-IPO.
Thank you, Michael. Yes, invalidity action is clearly one of the most frequent means of defense when it comes to registered design before the EU IPO, and probably due to the lack of substantial examination that was mentioned by Eva Maria before. So we wanted to share with you some interesting data regarding invalidity action, showing that approximately 550 invalidity action were filed during 1 year in 2019. The vast majority of them were grounded on the lack of novelty or individual character. And it's interesting to note that the average invalidity rate was rather high, 65%. Next slide, please. So the invalidity, the condition to be valid, there are two. To be valid, the design, as we mentioned before, should be new and have individual character. So the novelty means that no identical design has been made available to the public before the filing date of or the date of priority. And the individual character means that the design creates an overall impression which is different from earlier design on the informed user. Next slide. So how to challenge novelty and individual character? You have to prove the disclosure. So the disclosure, it can be an identical or almost identical design for the lack of novelty, or it can be a design that meets what is called the 4-stage examination step to destroy the individual character. This 4-stage examination test has been developed by case law and is based on 4 factors that have been defined. The first one is the sector of the product, defining which sector, the sector to which the products belong. The second one is a definition of the informed user of the products, who is very, very important, as Christina, we mentioned it before, because it is based on that you will assess the degree of awareness of the prior art and also the level of attention in the comparison of the design. Then you take into account the degree of freedom of the designer. And finally, the comparison, which must be made globally, taking into account the features that are protectable and excluding, for example, the functional one. So what are the relevant prior rights and how to identify them? Any type of design or product made available can be a relevant prior art. They can be made available by publication, by use, or by any means. And these prior rights can be identified also by any means, by design, by trademark search, by patent search, by knowledge of the market by your team of the operationals. And then it is also important to keep in mind that each prior right must be examined individually. There is no combination possible between the prior rights. And last question, how to evidence this disclosure and this prior art. So all type of evidence are admitted before the EU IPO as long as these evidence are solid and objective, even though it is admitted that you can combine or use together some piece of evidence. And of course, the evidence must be dated because you have to prove at a certain date that there has been a disclosure. And for example, it's interesting to note that the EU IPO has admitted that screenshot from Amazon Marketplace would be considered as admissible evidence of a certain date. And of course, a preference should be given to the evidence with the strongest probative value. For example, in France, we would use bailiff report, but Christina will also mention expert report and survey that are very relevant to prove the rights. And next slide. And finally, you should check that none of the exception to disclosure applies. So first, you need to check that the disclosure did not occur during the 12 months grace period before the filing date. It is interesting to note that even though it is not in the text itself of the regulation, in one decision of the Board of Appeal of the EU IPO, it has been considered that this grace period would be applicable only if the disclosure was made to test the product. And it has been ruled on the basis of recital 20 of the regulation. So it's not confirmed that this trend and this condition will be applied, but it's important to have it in mind if you have this question of disclosure. And then the last point is to check that the disclosure could have been reasonably known by the circles specialized in the sector concerned operating in the EU. So it is a condition of reasonable knowledge to make sure that an EU person could have been aware of the disclosure. So for example, if you have a trade show in the US, you have to assess if it has been attended by exhibitor or participant from the EU to make sure that this condition is met. And now I will hand over to Michael for the functional criteria.
Yeah, thank you, Nathalie. So 2 words on the technical restrictions and designs of interconnections. So features of appearance of a product which are solely dictated by technical function cannot be registered as a design. The reason is that design law protects the appearance of a product and technical solutions are reserved for patent law. And so otherwise, there is an undue accumulation of rights. But how do we assess this? There's 2 approaches. There's the first, a multiplicity of forms test, which says that if multiple forms are possible of the same technical solution, then this means that the appearance is not solely dictated by technical function. A second approach that was considered before is whether there's a no aesthetic considerations test. So if a certain appearance there were no aesthetic considerations, but only functional considerations, then it's solely dictated by technical function. The European Court of Justice has endorsed the second approach, saying that whether the alternative designs exist is not decisive. The decisive criterion is whether there were aesthetic considerations when making the appearance of the product. And if there were only functional considerations, then it's not registerable as a design. A second point is the relevance of patent showing the same product. So design owners will sometimes file a patent for a technical solution and then file a design for the appearance of the technical solution. And if the product in the patent application is the same as in the design, you may have a good argument to argue that actually there was no visual enhancement, and therefore the product is solely dictated by technical function. That was the bunch of balloons case of the General Court of the EU. A second point is a must fit exception. The must fit exception covers designs of interconnections that must fit like a key into a keyhole. So it concerns interconnections with two corresponding parts. In that case, there can be no protection for either the corresponding parts, i.e. the key and or the keyhole. Interestingly, there is one big exception to points 1 and 2. It's where the technical solution and the must fit are part of a modular system. Then suddenly you can obtain design protection. This modular systems exception was introduced in the regulation under the impetus of Denmark to protect Lego. So it's no wonder that Lego is indeed invoking that exception to obtain protection for Lego blocks. And you can see the reference on the slide. Thank you. I will now hand over to Christina, who will guide you through the actual litigation and the evidence that you have to submit.
Thank you, Michael. So I am going to cover the last part of the presentation. I'm going to focus in the main dispute, and in the next slide, please, I will be concreting the evidence necessary to achieve good results. If we can move to the next slide, please. Yeah, so the idea is to give you a practical overview about what we heard already from Eva Maria, Natalie, and Michael. This is going to be concreted based on our experience and of course on EU law applied to designs. So the messages that I am going to share with you are definitely useful before the EU IPO, the General Court, and the Court of Justice. Also useful to those cases before national courts within the EU system. But I believe that can be also of use for those cases in national courts outside the EU, but that are influenced also by the EU guidelines and so on, like for example, in Switzerland. Next slide. So I'm going to start about explaining how, in my view, we can better support contest novelty. And for that, I'm going to use a real case. The images that you are going to see are public, so they are in the decision, in the main decision of the case. So I believe that it will help us to understand how to choose the better evidence in every case. Next slide. Starting with novelty. So as Natalie explained us, when we need to assess novelty, let's think about a contested design like the one that you are seeing in this image. The first thing that we need to make, as Natalie commented, is to identify which are the main features, the main characteristics that describe this design. Once we have identified those, we will need to check whether the prior designs that were disclosed also show that main features, that main characteristics. The question is it us as lawyers who have to identify those designs? It is, my response is clearly no. We are not having the technical background in order to determine which are the main features which identify the ornamental part of this design. For example, if you see the two bands that go horizontally in this bottle, once I started handling this case, I understood that they were intended in order to avoid the label to move. But of course, if you do not have that technical knowledge, you may think that those bands serve for a design purpose, and that's not correct. So it is clear that it is not in our function to do so. It is not either in the judge function to do so, because the judge normally will not have also that technical background. So here is where we need the expert report. The expert report should be a person that has the necessary knowledge and background in order to identify which from that characteristics are not technical, are not standard, and allow to identify the ornamental part of the design, and second, to what extent that characteristics are also present in the prior designs, such as the case that you are seeing here. If we move on, this is an example in the next slide of how the expert report looked like, the one that we use for that case. Of course, as you may already know, the best thing would be to have a report very clear, graphical, understandable for the judge, because we are mentioning very technical issues in order to make sure that we clarify which is concretely the ornamental part of the design. And for example, this report was prepared by a professor in the design faculty of Barcelona. So you need to make sure, of course, that the person preparing the report has the necessary knowledge, but not only that, we need to test also that that person has the skills and the capacity in order to appear in court, because we may have an excellent professor, excellent expert explaining the features of the design, but once you have him or her in court, you do not know how this person is going to respond, is going to act, and whether he or she can be confused by the questions of the counterparty, can feel intimidated, can get into contradictions. So this is an area that it is important to manage and to be as comfortable as possible. That would be for the novelty. And then we move on to the next slide. Yeah, and what's the evidence, and then to contest or support singular overall impression, the singular character. If we move on, next slide. The individual character. It is sometimes happen that there are mistakes when preparing the evidence that we see, that it is understood that the same expert report who provided the evidence to decide whether a design is new or not has the capacity in order to ascertain whether a design has individual character. In my view, this is completely wrong, because that expert cannot, or in most of the time, is not the informed user that it is requested by law and by our case law. So as you know, the informed user, it is a figure that our case law has defined as someone that knows the design. It is not an expert, has no the technical background of the expert, but knows the sector and knows the designs. So in most of the cases, the informed user does not exactly correspond with the general consumer. So this is something that you need to have in mind when testing the individual character. Natalie mentioned us before that when assessing the individual character, it is very important to look at the sector. In the example that I'm showing you here, imagine that this design was intended to ornament or the design of a premium water bottle. But the problem was that if when we applied for that design, the sector was identified as bottles as such, without mentioning premium water bottles, when it turns to decide which is the sector that applies and the informed user, we will have to attend to the wide sector of bottles, meaning that this bottle could be not only a water bottle, but it could be, for example, a perfume bottle. So that means that it is very important that when you decide to apply for a design, you use the Locarno classification, that's right, but also we need to specify very concretely which is the sector that we want to apply the design, because at the end, that will measure the scope of our design. If we move on, next slide. Yeah, so we identified the relevance of the informed user. Also, Natalie told us about the designer's degree of freedom in developing the design, because you know that the standard features need to be taken out of the comparison. We need to rely only in the ornamental part, in the specific features of the design. And once we have identified the sector, the informed user, and also which are the features that define our design, it is the time to make the comparison. In my view, since we most of the times are not the ones in place to make such a comparison, one of the good evidence to do so would be using a survey evidence. And that makes me just to launch the next polling question before getting into the survey part. The question is, do you keep, I cannot see it here. Do you use market surveys to support contest individual character or the overall impression produced by two design? Yes, no, don't know. If you submit, and thank you. So you see, it's interesting because so we have more or less the same quotes for yes and no, and we have a 40% about don't know. We do. Some of the participants, they do not know whether they use market survey. So that's interesting, and moves me to the next slide, please. Yeah, and then the survey. Is it necessary and how to prepare it? My response is yes, it is necessary in some cases, as we will see now. And of course, if it is well prepared. If we can move on. Yeah, and the next one. The preliminary steps. Okay. So when and why it is necessary? The first thing to mention is that when we decide to use a market survey, my advice is that we cannot rely on those market surveys already available to the company. We cannot just entrust our marketing colleagues to run that market survey and then revert back to us. We need to be really involved, because first we need, of course, that survey to be carried by an independent and recognized institute or company. And there are some preliminary steps that one has to take. First, have we informed the research company that we are going to use that results in a case in court? Because I remember many, many years ago, we had a case, very important case, where all of a sudden, when the market researcher knew that we were going to use that survey, they said, no, I don't want the survey in court, because the adverse party could be a potential client. So we had a big issue. We finally convinced the market researcher, but from that moment, we always make sure to inform that that survey is going to be used as evidence, because we have to also be aware about who is going to sign the report, because we maybe want that person to be in court to explain the judge what's the methodology, what's the results, and what's the impact in our case. And like I mentioned in the report regarding the novelty, we need to ascertain whether that person is the best candidate in order to defend the report before court. Let's go in my last 2 minutes with 3 examples of questions and responses. Next slide, please. So this would be typical question in line with the EU IPO and General Court guidelines in order to test the singular character, okay, in a scenario where image B has been contested. So one considers that image B is not a valid design because has not the singular character, because there is this prior design in image A that we consider that has the same features. Who has to answer this question? It is not the general public, it is the informed user. Who was the informed user in this case? Okay, we know that is that person that knows about bottles, water bottles in that case, if it was concreted the sector in that respect. So we decided to test to those professionals working in bars, cafeterias, hotels, shops selling beverages, and also commercial people in the world of the beverages and also crystal bottles. All those people, they form the informed user and were asked, would you say that product in image A produces the same overall impression as the design in image B? And then there was a yes. 68% considered yes. So with this result, you can go to the general court, you can go to the EU IPO, and if the methodology has been correctly put in place, you can tell the judge 68% of the informed user consider that they have the same overall impression. Moving to the next one. The text would be, the test would be the same, and in case of an infringement. So here we have a post design, which is image A, that was launched after image B, and the holder of image B considered that image A infringed his design. Okay, again, we need to ask the informed user the same question, because it is the informed user who has to decide whether image A produces the same or different overall impression as per design in image B. 80% of the responses were no, they do not produce the same overall impression. You can say maybe it is because in image A we can see the trademark, maybe because of the label, maybe because of the blue. But what it is clear, and I am fully aligned with that, is that image A, the post design, needs to be shown as it is in the market. It will be not a good exercise to remove the brand, because we are not testing a registered design here, we are testing a product that is in the market. And finally, the last slide, I wanted just to show that in a passing off and fair competition question, the test would be different. Here, we have to show the two products are in the market, image A and image B. And those who have to be interviewed, here, it is the general consumer. It is the consumer who needs to decide whether I believe that image A is linked, it's associated, or in somehow related to image B. Here, the informed consumer does not play any longer. We are out of the individual character, singular character. In a case of passing off, you would need to rely to the general consumer. And just to finish my presentation, the last slide. So if a consumer survey fulfills the requirements, I believe that they may give you a very good starting point in the absence of positive evidence. The General Court and the Court of Justice are every time more and more saying that they decided this because the party did not submit a market survey when they could do that, contributes to a favorable court impression, and may be useful in rebutting evidence also launched by the counterparty. I will just finish here, and I'm open to questions, and will now hand over to Michael for questions and closing. Thank you very much for your attention.
Thank you, Christina. So we've come to the end of our session today. Thank you all for attending, and thank you to the speakers for sharing their insight and experience on these topics. Design law is an exciting area of law that is developing and that we're monitoring closely in our day-to-day practice. If you have any questions regarding the topics discussed during this webinar or design law in general, please send them through the Q&A box at the bottom of the screen, and we will do our best to respond to them offline. We have run out of time, so maybe very quickly, there was one question on the specialty requirements. So in the Nivelle case law, that's the Easy Sanitary Solutions first group Nivelle case, the European Court of Justice impairs the notion of sector. So your design may be invalidated if prior art was found in another sector. So for instance, there was a case where designs applied to products as distinct as watches and aircraft clocks may produce the same impression on the informed user. And so what do you think of the impact of Nivelle? And so, well, personally, I think that's indeed a big impact. It's very broad. And actually, the design regulation is currently under review. So it dates from 2002. And there is a lot of lobbying to get that specialization requirement into the regulation to alter the jurisprudence of the European Court of Justice. I don't know if any of the other panelists wants to add something to that. If not, we'll just wrap up here. We'll again put your questions in the Q&A. We'll answer them offline. As mentioned before, our Litigating Designs webinar series is a global one. So if you're interested to learn more about the other sessions, let us know. Once again, thank you for joining us, and we hope to see you again soon. Thank you.